Welcome into the Trevor Staub Show, episode number 59. Today we are bringing back on a returning guest. We have Chris Clark. He's the founder of discgolf.law. A lot of you have probably seen him during the recent developments in the legal cases of Gannon Buhr and Natalie Ryan. Well, I'm bringing him back on the show today to talk all about those cases and give us some insight from an attorney at law. But first, we have a quick word from a sponsor. Today's episode is sponsored by Kraft Double G Jerky. If you've been watching all of our shows and videos for a while, you know that we love Kraft Double G Jerky. They have all kinds of amazing flavors, such as hot boom sauce, teriyaki, garlic lover's dream is one of my favorites. A whole bunch of different flavors that they offer. They also support the Double G Children's Foundation. For every bag of jerky that you buy, part of the proceeds goes to that, and that plays in part for buying discs and baskets for inner city children. Another thing is with every bag of the Max Weight or McBeast barbecue flavors that you buy, part of the proceeds go to the Paul Macbeth Foundation for that. They also offer smaller 1 ounce bags of jerky that are perfect for players packs. So you probably see me wearing the Double G Jerky hats very often. You can check those out on their site as well. Right now, with your order, you can use code Foundation. You can get 10% off. Make sure to check out Double G Craft Jerky. A lot of awesome flavors. Check them out. Code Foundation at checkout will get you 10% off. Let's go ahead and hop into the interview. All right, we welcome on our guest for the show today. Today we have returning guest, the founder of discgolf.law, Chris Clark. Thank you so much for joining the show again, Chris.
Yeah, it's great to be back, Trevor. Thanks for having me.
Yeah, I kind of guessed the last time you appeared on the show that it would not be your last appearance on the show because there was a lot of open doors in the legal sphere. The last time, we were talking about Gannon Buhr, and we'll talk a little bit about that, but we also have a lot of the Natalie Ryan case to get into. But first, I want to start with the Gannon news, because that lawsuit was dropped by Prodigy. Is this an outcome that you kind of saw coming for this case?
I think so, and it doesn't make me any kind of brilliant legal mind or able to predict the future. I think the case essentially boiled down to a financial dispute, and most cases like that do settle. And so it didn't surprise me, and that is what I predicted the outcome would be. Interesting that part of the outcome was that Gannon remained on and agreed to fulfill the remainder of the term of his contract. Right. I wasn't sure about that. I wasn't really sure whether part of the settlement would be that they release him and permit him to go and sign with another sponsor or not. But it does seem like that situation is resolved, at least for the time being.
Yeah. So I wonder, the whole thing, it kind of like had. There was a lot going on when it first dropped, like the lawsuit. There was a lot of tension between the parties. It seemed like Prodigy was, alleging they were really caught off guard with Gannon posting all of a sudden saying he's leaving. Like everything was very, tooth and nail. And then things kind of simmered away. Gannon started winning again. And we kind of just got to this weird spot. And my question is, obviously there was a statement that we were given from the Prodigy CEO, and they do kind of mention the word resolution, and that can be taken, I think, a few ways. Like, my biggest question is, do you think that resolution was just used in the terms of we came to an agreement that we're just going to continue as is and bygones be bygones? Or do you think Prodigy, the resolution had more to do with something they could have gotten out of their end of the deal, such as certain promises pertaining to the next offseason?
Yeah, that's a great question. I think you keyed in on that word because it can mean so many different things.
Right.
And in this context, all we know as outsiders is just that the lawsuit's been dropped and, Gannon is continuing to throw Prodigy. So I think, your the suggestion that you made as part of your question, I think is entirely a possibility. My hunch is that they ironed out a few things and said, look, Prodigy wants to focus on selling discs. Gannon wants to focus on winning tournaments. Let's each get back to what it is that we really do best. And, let's see what kind of agreement we can make in order to do that. And that's, I expect what happened. And unless somebody chooses to talk or release some documents, that may be all we ever know.
Yeah. Well, and I feel like, do you see it often in legal situations where you have two parties that even if one feels like they may have an edge on the other, there's legal fees and a lot of like headaches involved in that. So is that something where it's a lot of common to be like, hey, let's just both kind of drop our weapons and just let this thing go so it's not a headache for us anymore?
Absolutely. And I wish that more parties had the discipline and the presence of mind to really, analyze that as part of the cost benefit analysis of going into battle against another party. Um, you know, one, lawyers and legal fees are not cheap, and it's a real struggle the way that our judicial system is set up. If you have an amount of money that is incredibly meaningful to somebody like you or me, but in the lawsuit world isn't all that much money. And I mean, I'm talking like 50, 75, $100,000 in dispute.
Hmm.
You can easily spend $100,000 in legal fees on a commercial litigation case.
Yeah.
Um, and so I do think, that's a smart observation on your part, that it very much could have been the two of them looking at each other and saying, hey, in addition to this being a distraction and a headache, it's going to cost both of us, the more this drags on, it's just going to cost us a bunch of money. And at some point, it may cost more than the amount in controversy. So yeah, I
Right.
think that's likely was part of it.
Yeah, I think a lot of people, and myself included, can overlook that sometimes. Be like, these legal fees, even if you win, like there's going to be costs involved, and because I know that Prodigy had originally included that clause where legal fees be paid um, by Gannon's party if they were to prevail. But then you would mention that those don't typically get granted in that kind of case either. So yeah, a whole lot going on there. But that case, at least for now, is done. I'm sure we'll hear more about everything once the all season comes into play. People will be looking very closely at that situation. But for now, it's done, and we're going to jump into the Natalie Ryan case because this is where things are far from done. We get towards the OTB Open. Things quieted down after that original complaint that was filed earlier in the year, and I think a lot of people there's some people probably had just kind of forgotten about it. There were some people that were just kind of like, I guess nothing's going to happen further. And then, as we got closer to the OTB Open, could you kind of smell the possibility of that last minute request, of that restraining order from Natalie's team, or did that surprise you, the timing?
Um, I, I would say probably somewhere in between.
Okay.
I knew that from, having read Natalie's court documents that were filed, that one of the things she was asking for in her lawsuit was that she be permitted to play in the FPO division in the OTB Open. And so, as the days and weeks went by, and as the OTB Open kept getting closer and closer, um, I was both surprised that we hadn't seen any kind of movement on that, and also, I guess, a little bit in the back of my mind, expecting that maybe something would happen. Um, and sure enough, her counsel did file that motion for an emergency temporary restraining order. I think it was the Friday before the tournament started.
Hmm.
There was some discussion in the court filed documents, particularly from the Pro Tour and the PDGA, that hey, Natalie shouldn't have waited so long. This wouldn't have been an emergency TRO. They've known when the OTB Open was, and this policy has been in place for a long time. They were arguing it didn't necessarily have to wait that long,
Yeah.
and shouldn't have waited that long. But the court went ahead and heard it anyway. So yeah, I knew the OTB Open was an important date in that case, and so it didn't really surprise me that much.
Do you think that, and I know a lot of people have speculated about this, but do you think that the timing of that request was deliberately brought on so close to the event? And is that something that's common strategy in the legal world?
Yeah, that is a really interesting question. I don't think there's a way for us to ever know for sure, but my sense is it was not strategic.
Okay.
Um, and I base that in part on, an interview I heard with Natalie's counsel, where he was talking about this issue of having waited until the week before the tournament to file. And he said that he was hopeful that them waiting so long to file would not hurt Natalie's position, and he
Mm.
was concerned that it might, and he was grateful that apparently in the eyes of the court it did not hurt their position that they waited so long. So the fact that I think he was concerned that the delay might have negatively affected her case, that suggests to me it probably wasn't a strategic decision.
Interesting. Yeah. Okay. That's helpful context. Obviously, yeah. If it would have, even if it was strategic, and if that had hurt their position, it certainly would have backfired in that case. Um,
Right.
so when that request first came in, because you were obviously at this point, were you on site at the OTB Open when the request came in?
No. So let's see, their motion for a temporary restraining order got filed, I believe, the Friday before the tournament. I didn't actually become aware that it had been filed, I think, until at some point over the weekend. It may have even been Monday. And we were set to head out to Stockton on Thursday.
Okay.
So some things happened early in the week, I think on Monday, and then things were basically happening every day.
Right.
And so we were trying to keep people informed. We were doing some videos on our YouTube channel, just trying to let people know what was going on. One of those videos we recorded in the rental car as I was
Yeah.
driving from San Francisco to Stockton. But yeah, it all kind of started going down just really that full week leading up to OTB, and some things happened before I went, and obviously some things happened while I was there.
Yeah. So when the request first comes in, I feel like from the tone of your original video, you didn't seem super optimistic about it working out. Is that kind of like what your overall feeling was at the beginning? Was like, you weren't really sure it was going to go through?
I've given this a lot of thought. I I have always said I think that Natalie has an uphill battle in ultimately getting the result that she wants
Yeah.
from this case. And I formed that opinion fairly early on. Since then, I've read the law in California that her lawsuit is based on, the UNRU Act, or the California Civil Rights Act, sometimes it's called. I have also read the decision from a court in Minnesota about a similar case involving
Yeah.
powerlifting. And so I would say that my uh, feelings about her likelihood of success overall, I think it's maybe a little more likely that she will succeed than I originally thought. I still stand by my statement that I think the ultimate resolution that she's looking for, I think there's still a big uphill battle to fight. And not at all saying that it's not going to go anywhere and that it's going to fail and that she's not ultimately going to succeed. I just don't think it's likely ultimately. And there's a lot of complicated reasons for that. Um,
Yeah.
and you're right. I mean, early in the week, I thought it was unlikely to succeed. Once I read the decision from the district court, with the exception of this jurisdictional issue, I mean, we can talk about it if you want, but I actually thought that under the California law, under the California statute, I actually thought the district court applied the law correctly.
Yeah.
Um, their decision got reversed on the basis that the trial court didn't ultimately have jurisdiction over the Disc Golf Pro Tour, which incidentally, that decision could have a big impact on this case. It's unclear to me exactly what that would be. There's a bunch of different options that I've kind of hold in my head at the same time. But yeah, I am still thinking that if I had to pick, yes, she will get what she's asking for ultimately, or no, she won't. I think it's likely that she won't, but it's a difficult, complicated, close call to make.
Yeah. So I actually, you mentioned that case in Minnesota, and this is something that I read pretty much as soon as the original complaint was filed. I read over that case, and in my mind, I found some differences in between the two cases as far as how because the one I'm referring to, for those of you listening, is there was a weightlifting case in Minnesota where a transgender athlete was actually ended up being permitted to compete in the event. If I remember correctly, though, that case there was a little bit of difference in the fact that they didn't quite have the policy in place. They almost improvised the policy a little bit. I felt like there was a little bit of difference in the fact that the Pro Tour had implemented their policy a little bit differently and further ahead of time. But do you think that there is, because a lot of people are mentioning the Preserve as being the next event where could Natalie Ryan use precedent from this weightlifting case to get into the Preserve? Do you see any ground there, or have you read over it and seen some differences as well?
Okay, so I'll say two things real quick, and I'll take the sort of the second. I'm going to go in reverse order. I'll take the second one first. I believe I have heard Natalie's attorney specifically mention Minnesota and the Preserve as a possible place that they could bring legal action next. And
Yeah.
so you're right. People are talking about that as a possibility, and those people include Natalie's counsel. Now, when we talk of, our legal system is based on precedent. And so when we talk about precedent, we're looking for cases with similar fact patterns to ours. And so if you are Natalie's attorney, your job will be to argue why Natalie's case is similar or identical to the JC's case, the powerlifting case. And then it will be the job of the defendants, presumably the Pro Tour and the PDGA, to argue to the court why their situation is different or distinguishable from the powerlifting case. And so I haven't studied the Minnesota decision closely enough to form an opinion on how similar or how different it is. There's always going to be differences. So there's always going to be a way for the defendants in this case to point out differences. The question will be, can they persuade the court that those differences are important enough that the court should decide differently in Natalie's case than it did for the powerlifting case?
Yeah. Okay. Yeah. I think from what I've read, I think it could be very interesting, and that could be a seriously interesting hearing to hear them go over that and try and compare the two cases. But yeah, I'm expecting there could be some fireworks surrounding the Preserve. So somebody who was on the grounds at the OTB Open, describe the atmosphere at the event after the initial request was approved. What was it like being on the grounds in the midst of that?
It was wild. So we showed up at the course, I would say probably 45 minutes to an hour before the first FPO card was scheduled to go off. And that was the card that Natalie was on.
Yeah.
And there were already supporters in the parking lot with signs. And I'm sorry, when I say supporters, the people I'm actually talking about were supporters of the FPO players who had signed this Stockton declaration,
Yeah.
Urging the court to not allow Natalie to play. So the way that I knew that, the way I knew that was that many of the players in the FPO field, as well as these spectators who showed up in support of the players in the FPO field, they were all wearing pink and black.
Yeah.
And they had signs. And so look, I really enjoy spectating the FPO division, and I've been at a lot of early FPO rounds at tournaments, including Elite Series tournaments, and frankly, there's hardly ever much of a gallery.
Yeah.
And this was an exception. It was it wasn't a humongous crowd by any means, but there was a noticeable gallery there for that first card to go off. And I will say on that first card, Natalie was on there, and I believe Stacey Ronsley was on there, who I believe was one of the people who signed that Stockton declaration. And so when Natalie teed off, there was a nice roar of approval or applause. I mean, roar is probably an exaggeration, but she got some nice applause when she teed off. And then when Stacy teed off, same thing, different group of people cheering and applauding, but she got a nice round of applause as well. Um, did not hear or observe or perceive really any negativity in terms
Hmm.
of people, shouting inappropriate things or something like that. And so that was the scene, like a lot busier than a typical early FPO card, and I would say supporters of both sides present and making themselves known.
Yeah, well, it's always good that, if it can remain peaceful, obviously, and not get
Yeah.
hostile. That's obviously what we don't want to see ever. But yeah, certainly like a lot of tension there. And when I saw the ruling came across, I think I saw just saw an Ulti World article got tweeted out, and that they were pretty on top of things, and I saw that go out, and in my mind things were kind of done. And then we started hearing about this appeal that could be going through. Like, we had kind of been like, okay, so Natalie Ryan's going to play the OTB Open. Wow, it'll be interesting to see what happens next. And then all of a sudden, we started hearing about this appeal, and we were like, oh my goodness, like, what is going on now? What's going to happen next? So when did you first hear about the appeal, and did that shock you?
I was a little shocked. I kind of uh, disappointed in myself a little bit because it had actually never even occurred to me that that might happen. And also, not being, our firm is rarely involved in litigation and has never been involved in any type of appellate work. And
Yeah.
so I wasn't even aware that you could go to a federal appeals court and get something heard on an emergency basis, like basically the next day.
Yeah.
Get something not only heard but ruled on by the next
Right.
day. So some appellate lawyers out there are probably rolling their eyes at how naive I am, and I just didn't even know they could do that. So that didn't occur to me that might happen. When did I heard about it? I had I'm trying to remember for sure. I believe one of my clients who is an FPO player
Hmm.
reached out to me and said, the attorney that she had been talking to, or somebody who had been in touch with attorneys for the PDGA, the Disc Golf Pro Tour, said they thought that they could get the ruling reversed on appeal on the jurisdictional basis.
Yeah.
So that probably was Thursday night, I believe. So I'm sorry, Friday night. So
Yeah.
Friday was the first round. Natalie played her round. First round was completed, and I think I was back at our Airbnb, and that's when I had gotten the news that an appeal was coming.
So explain this jurisdictional issue. How does that all work? And what is the reason for an appeal being able to made like that? It almost, like when I first heard about it, it sounded almost like a loophole. But like, explain to me what the real reason is for things like this to be upheld.
I think it is a bit of a loophole or a
Okay.
technicality. Uh, I will say this about jurisdictions. Well, a few things. Number one, jurisdiction can be an incredibly complicated concept. Um, and as I said before, with me not really being much of a litigator and not having to consider issues of jurisdiction very often, I am far from an expert. But I'll just try to give as straightforward explanation of the situation as I can. Um, this case was filed in federal court, and so in federal court, in order for a federal court to have jurisdiction over a case, there's really two general bases for jurisdiction. One is if it's federal subject matter. And so I'm going to bring it back to kind of my world, something I'm familiar with. We do a lot of trademark work for our clients. And so there is a federal trademark statute called the Lanham Act. And so if a case is brought under a federal statute like this Lanham Act for trademarks, that can be heard in federal court because it's a federal statute that you're arguing about.
Okay.
In Natalie's case, it is a California state statute. It's not a federal law that is the basis of her case. So they got to figure out a way to get into federal court otherwise. And so the other basis is what we call diversity jurisdiction. And diversity jurisdiction just means one party resides in one state, another party resides in another state. And so you can't really go to the court of the state where you live in that situation if one party is one place and one party is another place. And so the federal court will agree to hear disputes between parties that have different residences. And so the Disc Golf Pro Tour raised the issue of jurisdiction on the following basis. They said, Natalie is a resident of the state of Virginia. We have one or more owners of the Disc Golf Pro Tour that also reside in Virginia. And the rule is, if you're an LLC, if you're a limited liability company, and you have owners in a particular state, it can be said that that LLC is a resident of that state where that owner or those owners reside. And so the Disc Golf Pro Tour said, hey, we got owners that live in Virginia, and that destroys this diversity jurisdiction because now the LLC can be considered a resident of Virginia, just like Natalie is. There's no diversity, and therefore the court doesn't have jurisdiction. And the way that it played out was really interesting because at the hearing on the temporary restraining order, they called Jeff Spring, who's the head of the Pro Tour, to the stand to testify about whether the Pro Tour actually does have owners that reside in Virginia. And he said, yes, we do. Steve Dodge resides in Virginia. Not trying to pick on Jeff or belabor this point, but it turns out actually Steve Dodge does not reside in Virginia. But there are family members of his who have equity ownership in the Pro Tour that, according to the evidence that was presented, which is like their driver's licenses and things, they are Virginia residents.
Yeah.
And so based on that evidence, that's ultimately what the appeals court relied on in saying, yeah, it looks like the district court didn't have jurisdiction, and therefore it didn't have the ability to grant this TRO against the Pro Tour, and therefore we're reversing the court's decision.
So that is, I saw like a brief mention when I was looking through about this, like the fact that Jeff Spring testified, and like, explain to me, is it not perjury to do what he did, and how does that work?
I'm not an expert in what is and isn't perjury, so I'm going to refrain from responding to that.
Okay. I was very confused whenever I heard that part. Like, it was just kind of like inserted in there, and like there was like some line along the lines of like, even with Jeff Springs like falsely testifying, like that, something like that was written in somewhere in one of the filings, and I was like, like, now wait a second. So I found that interesting.
Let me say this in Jeff's defense. Jeff doesn't need me to defend him, but I think a reasonable person could believe that Jeff misunderstood.
Oh,
and,
yeah.
You know, that maybe Steve Dodge had said, you know, hey, I got family that lives in Virginia that are equity owners, and that Jeff misunderstood that he was saying that Steve Dodge lived in Virginia. I think there are possible innocent explanations for that, other than, you know, Jeff got up there and lied on the stand in order to get the case dismissed.
Right. Yeah, I agree with that. I don't think that it necessarily means like, oh, that was intentional. Because I guess, is that really perjury? Does it have to be intentional?
I'm not sure.
Okay. Yeah, I don't know. Fine line. Anyways, so after that appeal was granted, and, you know, Natalie Ryan removed from the event, that's kind of what we were left with. But I would imagine, if not from my own assumptions, then from the nature of Natalie's Instagram post, this is far from the last time we're going to hear about this. Where do you think Natalie's team will go from here? Do you think they attack another event like the Preserve and go make another case there, or are they going to start focusing on maybe a bigger picture and go that way?
Boy, it's a tough question. I'm really I'm afraid I don't have a very good answer for that. You know, this case in California still exists, and
yeah.
So, you know, I mentioned earlier, jurisdiction is a complicated concept or issue. to my understanding, the fact that the Ninth Circuit Court of Appeals issued a ruling stating that the district court doesn't have jurisdiction over the Pro Tour means, to my understanding, maybe one of a couple things. One might be that the Pro Tour is automatically dismissed from this case outright.
Yeah.
The ruling of the Court of Appeals should make it so that the district court can't continue to exercise jurisdiction over the Pro Tour. It may be a situation where now the Pro Tour files a motion to have themselves removed from the case. I don't know if they have to do something or whether this is just something that will happen automatically.
Yeah.
I don't think there is a scenario where, despite the appeals court ruling, the district court can still exercise jurisdiction over the Pro Tour. I don't think that's likely to happen. And so if I'm right, and if we assume that the Pro Tour is no longer going to be a party to this case, it really does beg the question, okay, well, what now? And does that mean you now go to somewhere like Minnesota or something like that? I don't know what states Natalie's attorney is licensed in, but to me, it seems likely he's probably not licensed in Minnesota. And so, she would need to find either find counsel there in Minnesota, or her counsel would have to apply to be admitted there on a temporary basis. It's called pro hoc vice. They would be admitted on a temporary basis just for the purpose of this case. The other thing that's a factor in this, unfortunately, is, as we mentioned earlier, legal fees are expensive.
Yeah.
My understanding is Natalie's attorney has been volunteering his time on this case.
Oh, wow.
And that's a massive amount of work to be volunteering for. And so, he would either have to recommit to continue volunteering to do work for a case filed in another state, or find another attorney that would be willing to do it pro bono, or figure out a way to raise a bunch of money in order to pay the legal fees in another state. So, it's just an unfortunate reality that you have to consider, is that if she does want to pursue this in other jurisdictions, it's probably going to take a budget.
Yeah, certainly. Yeah, I didn't even realize it was pro bono. That definitely makes a huge difference. Yeah, because so now I haven't taken a law class in a while, but my understanding is something goes to district court and then goes to an appeal court. Beyond that, it's the Supreme Court. Like, isn't that the next step there? So and that's obviously very unlikely in this scenario.
Yes, the general concept is correct.
All right.
So far, all that the district court and the appeals court have really heard or ruled on was this motion for a temporary restraining order. And so that the Ninth Circuit Court of Appeals reversing the district court's ruling on the temporary restraining order, I guess theoretically they could have asked the Supreme Court to hear that on an emergency basis, but
for a restraining order,
the open is over now,
right? Yeah.
And my hunch is the court probably wouldn't have granted certiorari, which is what they do when they agree to hear a case. So they probably wouldn't have agreed to hear it anyway.
So it'd be more likely if that were the path of a larger case, like against the PDGA, for example, if that were to go that route, rather than just this kind of one-off restraining order case. That makes sense.
And again, I mean, I'm a little bit out of my depth here because I'm not an appellate lawyer by any means, but I do know that historically, one scenario where the Supreme Court has chosen to hear certain cases on appeal is if, for example, the Ninth Circuit were to rule one way and the Fourth Circuit were to rule another way. Now, on similar facts, now we've got a divide between the federal circuits, and a lot of times the Supreme Court will agree to hear a case in order to settle that confusion.
That makes sense. Yeah. Okay. Wow. Well, there is, certainly a lot to unpack still, and I'm sure there's going to be more and more updates as we go on. You're going to be a busy man, certainly as this develops. Although I feel like it's crazy because, like you mentioned, this case, or at least a lot of things within this case, unfolded within a few days' time, which, to my knowledge, is not common in the legal world at all. Because I feel like, and correct me if I'm wrong, this could be something that happens over 4 or 5 years.
Yeah, I mean, 4 or 5 years would not be out of the question. I would expect, again, this issue with the jurisdiction of the Pro Tour has really thrown a wrench into the status of this California case.
Yeah.
But if we were to imagine that would not have happened, I could see that maybe, possibly getting heard and tried, maybe even before the end of this year or maybe early next year or something like that. But now, as I said, I'm not sure what the future is for that. But yeah, I mean, 2-3 years for a complicated or heavily involved commercial dispute like this or court case like this is not unheard of at all.
Yeah, certainly. It was a quick burst of excitement there, with a lot going on, but it definitely could be more drawn out as things go on. But yeah, I appreciate you coming on the show, Chris. We're surely going to have you back. I feel like the floodgates have opened now for legal situations. You might as well be our official legal correspondent at this point. But I always appreciate you being on the show and giving us some insight.
Appreciate the good work that you're doing. Always enjoy coming on, and happy to come back anytime.
Thanks once again to Chris for joining the show today. Always great having him on to get some of that insight on these cases. I'm sure it won't be long before we have to have him on again to explain some more developments in these cases. But until then, he is very useful. Make sure to check him out, discgolf.law. Go and look at all his videos. Anything legal issue that's covered in disc golf, he's always on it. And it's very, very helpful if you're like me and you only have a very basic knowledge of the legal system and all that stuff going on. Other than that, we'll be back with another episode next week. We'll see you then.